Good day, everyone. I am Tony May Miel Cardozo, and me and my group mates will discuss to you the criminal justice ethics. We are from the Department of or School of Business and Accountancy. So let's start the discussion.
So our topic for today is criminal justice ethics. So first, let us define what is criminal justice ethics. Criminal justice ethics examines the criminal justice system through an ethical lens by identifying ethical issues in practice and theory, exploring ethical dilemmas, and offering suggestions for resolving ethical issues and dilemmas faced by the criminal justice professionals. Another definition is that it is the academic study of ethics as it is applied in the area of law enforcement. Ethics are actually the very foundation of the criminal justice system. They are what help us, as a society, develop the moral reasoning we use, define criminal activity, and deem acceptable as punishment. It is an important topic because our criminal justice system is most effective when it is operating in the ethical manner. Criminal justice and ethics are closely related. According to the social contract theory, the denizens of country give up a certain liberties to be protected by the government, and criminal justice professionals are the agents of the government. Justice practitioners are expected to have a higher moral characters so that the common man can feel confident about the agent of the government that are affording them protections. Virtually all criminal justice professionals, be they police officers, judges, prosecutors, defense lawyers, correctional officers, probation officers, or parole officers, need to exercise the use of their discretion at some point or another during the course of their careers. Usually, this occurs when practitioners are faced with specific ethical dilemmas as opposed to taking a stand in matters involving broad ethical issues. When discretionary decisions are guided by ethics, decisions can be said to be fair and just, because there are always shades of moral obligations that are higher than others. The awareness and importance of ethics in the field of criminal justice are increasing in a fast pace. This because, as in virtually every other occupation, criminal justice officials are also engaged in unethical behavior during the course of their 8-hour shifts. Every year, there are practitioners who end their careers in disgrace by engaging in unethical activities. This includes behaviors that are outright illegal, as well as those that have not been labeled as being criminal in nature. It is noteworthy that every type of unethical behavior is necessarily illegal. In fact, criminal justice practitioners engage in many unethical behaviors that are not governed by the legislature and the court system. So in conclusion, criminal justice ethics discuss issues by exploring moral dilemmas faced by professionals in criminal justice system and then examining the major theoretical foundations of ethics. The role of ethics in criminal justice allows us to understand our real-life ethical issues before grappling in philosophical approaches to the resolution of these issues.
Let us continue to the second part of this discussion, which is the classification of criminal justice ethics. This discussion will have 4 parts. First is the difference between criminology and criminal justice. Second is the components of criminal justice. Third is deontological, utilitarianism, and natural law. And the fourth is the classification of criminal justice ethics. Before we proceed, let us determine the difference of criminal justice from criminology, because some people might misinterpret these 2 terms. When we say criminology, it is the study of crime, obviously, and its causes, costs, and consequences. While on the other hand, the criminal justice, this is the system which crimes and criminals are detected, detained, tried, and punished. Now, let us move on to the second part of this discussion, which is the components of criminal justice. We had three components of criminal justice. First is the law enforcement, second, court system, and the third is the correction system. We'll talk about the law enforcement first. When we say law enforcement, this is the police patrol communities to help prevent crimes, to investigate incidences of crime, and to arrest people suspected of committing crimes. Law enforcement, its function is most visible, wherein police officers are typically the first contact a criminal has with the criminal justice system. Second is the court system. The court system consists of attorneys, judges, and juries, as well as the ancillary staff. The guilt or innocence of a suspect is determined in court. So basically, in court system, this system will process if the suspect is guilty or not. The suspect became the defendant and offered the opportunity to defend himself in court as evidence presented. If he is found guilty, the suspect receives a sentence or punishment based on criteria set by judge or institute. So the defendant turned over to the correction system after sentencing. And that leads us to the third components of the criminal justice system, which is the correction system. This system incorporates all forms of sentencing and punishment, and it includes incarceration and probation. This correction system leads to the conclusion that convicted criminal is the responsibility of the correction system until their full sentence is served or commuted. Let us now proceed to the deontological ethics. These posits the wrongness and rightness of actions does not depend on consequences but whether or not they fulfill the duty. So in essence, a deontological decision assesses the morality of one's action and disregard the consequences. Because basically in deontology, these duties are absolute and must be applied to everyone equally. That is, according to Su and Ma in 2016. So going back to deontology. In law enforcement, it is required to execute their duty under all circumstances, regardless of whether they want to or not. So as a result, this requirement is without equivocation and naturally becomes an imperative. So, for example, if a person believes that lying is wrong, then under no circumstances it is permissible to lie. And the categorical imperative that was imposed by Immanuel Kant is central philosophical underpinning of deontology, and it emphasizes that there is supreme principle of morality and further, that the end result is not primary importance. And also, Kant believed that everything that a person does is born out of goodwill. This tells us that while a person's action might be morally correct, it is possible, rather, that others perceive the act to be morally wrong because it was not influenced by goodwill. So, this brings us that Kant might think that people only focus to do certain things because they are driven by the morality of the categorical imperative and not the consequences that might follow the actions done. So a person's categorical imperative is what commands that persons into action or avoid an action because of its consequences. We will now move on to utilitarianism. So this posits that morally right action which produces the mass good. So Jeremy Bentham and John Mill were responsible for having engaged in some of the more notable accounts of utilitarianism. So Mill presented that there were some end goals that influenced every action that person committed. So during the identification of right and wrong, good from bad, a law enforcement officer should always be interested in defining what the good and bad consequences might result in making such a determination. So for this reason, we may identify the people have different views on what the consequences of a certain actions should be, and this may differ radically from law enforcement to the other components of criminal justice and even those law. So these wide-ranging views that critical for law enforcement to consider when assessing a group perception of what is reasonable or what is ethical and apply these to their interaction with an offender if part of their group. So, examining different aspects of the utilitarianism, these assess and develop us to the moral decision making in law enforcement, because Bentham and Mill's concept of utilitarianism are considered as the prominent ones, and they are commonly identified as hedonistic utilitarianism, because people by nature tend to find the happiness that is characterized by pleasure. So happiness is therefore linked with pleasure as well as lack of pain, while conversely, being unhappy is related to pain, which withholds pleasure. So in this context of law enforcement responsibility, determining how to be best meet prospective law and balance that with what is deemed to be acceptable in the terms of societal norms, and it is the very crux of the issue. So this utilitarianism can also be instructive in terms of deciding whether a specific act is considered to be ethical or unethical, by first determine whether it is offender or the victim whose happiness should be considered. For law enforcement to find a suitable way to deal with this situation, it is essential to examine all aspects of their activity or action, because law enforcement in the context of utilitarianism will have to compare the weight of the action that causes happiness for the larger group of people and what action produced the most good. So if the action causes more pain than pleasure that is derived from it, and then one might conclude that the most correct ethical action is that which is associated with the right amount of pain. Now we will proceed to natural law that was built by Thomas Aquinas, which came from the ideas of Aristotle. So natural law, as you can see, it is an absolute theory of ethics that is not rooted in duty or externally imposed laws. Instead, it is found in our human nature and our search for genuine happiness and fulfillment. There is natural order in our world, determined by some supernatural power that should be followed. So human beings are naturally inclined toward its moral code. The moral life is a life lived according to reason, because we live with a purpose. We are living for a purpose and a reason. So by discovering our end or telos or purpose, we can work out how to achieve this. So it does not give a fixed law, it is not always straightforward, and there is some flexibility in its application. If we are going to determine the classification of criminal justice ethics, if we are to classify the criminal justice ethics, what would it be? So we must consider the information mentioned recently. For law enforcement and other components, it is a suitable way to deal with situation that is essential to examine all aspects and actions of its context of utilitarianism. And we'll have to compare the weight of action that causes happiness for a large group of people. So therefore, we lead to the conclusion of embracing utilitarian principles in this aspect may help produce the long-term results of happiness and good outcomes for largest portion of community, but clearly law enforcement and other components of criminal justice ethics, those act will have different outcomes for different groups. So we may classify the criminal justice ethics as utilitarianism.
So, hi, good day. My name is Grace. I'm from Tomagas. So, our next topic would be criminal justice philosophers. So, let's start with the father of criminal justice. He is Cesare Picard. So, he was born in Milan on 15 March 738. He is an Italian criminologist, jurist, philosopher, and politician who is widely considered one of the greatest thinkers of the Age of Enlightenment. So, he is well remembered for his treatise on crimes and punishment, published in 1764, which condemned torture and the death penalty. So the book was founded on beliefs in rationalism and utilitarianism. So Beccaria believed in punishment as long as it was logical, adamantly spoke out against torture tactics, and supported preventative measures against crime over punishments. So he also believed that the root of crime is not original sin, but social injustice, and thus the church should not interfere with the judiciary system. So do you agree with that? Okay, next, Douglas Hossack. He is an American legal philosopher, academic, and author. So he is the author of Ignorance of Law, a Philosophical Inquiry. So this book argues that ignorance of law should not usually be a complete excuse for criminal liability. It defends this conclusion by invoking two presumptions. First, the content of criminal law should conform to morality. Second, mistakes of fact and mistakes of law should be treated symmetrically. So next, John Rawls. John Rawls was an American political philosopher in the liberal tradition. His theory of justice as fairness describes a society of free citizens holding equal basic rights. So this ensures that no one is advantaged or disadvantaged. Okay, so that's it. I hope you enjoyed and learned something new. Thank you.
Good evening, everyone. My name is Riza Joy D. Estrada, and I'm gonna be your reporter for today. Today, we're going to talk about the criticisms of the criminal justice, and we have here the justice, the criminal case, the analysis, and the criticisms. The first one is the criminal case. Of course, when we're going to get the justice, we should get involved first to the criminal case. Criminal case happen when the government files a case in the court to punish someone for committing a crime. It is the time when the person commit a crime already. And the second is the analysis. Of course, analysis detailed examinations of anything complex in order to understand its nature or to determine its essential features. For me, the easiest way or the simple way to define what is the analysis mean is to understand the situations, and to find a solution. That time, the people who are going to conduct is the professionals. They are the policeman, the scene of the crime, and the judge, diba? The judge is the one who manage. They have a power, to get jail the person or to release that person, because that time a judge, they need a witness. I'm sorry for the They need a witness so that they can have an enough evidence. Okay? But what do you think, or why do we think criminal justice receives a criticism? During in these days, not all of them, but most of them or one of them are using their power. They are abusing their power to have a money, of course, to have a wealthy living. That's why they are doing that. And in that, I'm going to show you some examples. The first one is the movie. It is called Hope. It is a very young girl who live in a small village, and they don't have enough money, but they are happy and contented on what they have. But the girl got raped. He got raped to a very influenced person. He is a well-known person. He has a money. That's the biography of that rapist. So at the end of the story, the girl died due to the complications that she received, while the rapist, he get released. That's the power, diba? You see, that's the power of money. That's the power. He paid the judge, he paid the policeman. That's why he got released, and he lives like nothing's happened. And the second one is the very well known scenario right now. It is the when the policeman grabbed a person and stated that he is a drug addict, even though he is not. They are just going to put the policeman will going to put a drug into the pocket of that person. Why? So that the people sympathize, or have the policeman have an evidence that the person is a drug addict, even though he is not. And that time he got caught. The policeman, he got caught. He got caught that he is putting a drug into that person's pocket. That's why a lot of people criticize that policeman, and some of the people didn't believe what's policemen usually do. Of course, because they already did bad. That's why they have a little doubt. And some of the example is the judge. When you know a person and he is a he is defendant, the judge will release him, or the judge will release her, because he know that person, even though the judge know that the person already committed a crime. That's the power. That's their power of being a judge or a police. They hold a power to hold someone. And of course, the money. Next is problems encountering of criminal justice. We have here the human trafficking, the drug crime, the cyber crime, and the mental illness. I'm not going to report it one by one, because I know that you already know what's the meaning of that. And thank you for listening. But before I end this report, I just wanted to say something, because my topic is criticisms of criminal justice. Of course, I'm just going to be fair and say my thoughts. Since criminal justice, we know that I am saying here that not all of them. It is one of them abusing their powers, but not all of them. Okay, so please respect our judge, respect our policeman who is doing the right thing, who is doing their job right. And I'm just here saying that don't don't be a bias. Don't be a bias and see the situations fairly, so that we can be full totally. That's the end of my report, and thank you for listening.
Now, let's move to benefits of criminal justice ethics. First, it improves the analytical skills and reasoning abilities that needed to understand the practical and theoretical aspects of criminal justice system. Second, the criminal justice professionals can quickly recognize the ethical consequences of various actions and moral principles involved. Next, the professional will be naive about moral issues occurring within the criminal justice system without the knowledge of criminal justice ethics. And lastly, it increases the sensitivity to issues of right and wrong, and it helps in the identification of actions with moral substance. That's the benefits of criminal justice ethics.
Good day everyone, I am Franny J. Meneses and I am here to discuss how are these specific or the following issues related to our chosen topic or theory, which is the criminal justice. So before we start, let me first ask you these questions, guys. Is it right to take a life, or is it even justifiable? Because our first issue is all about taking of human life, or simply means killing. When we hear about these killings, we always view it as negative or bad doings, whatever reasons we might have. Then if we all agree and believe that killing is an immoral act, then no one should be exempted. It should be applicable to all of us. Or in short, if no one cannot kill morally, no one should kill at all. Since we have the Article 2 of Human Rights Act that protect our right to life, this only means that no one, including the government, doctors, or even your parents, has the right to end your life in any way. The only responsibility of the law is to take appropriate measures to protect you when your life is at risk. Taking of human life or killing is morally wrong on at least some occasions. What precisely makes it wrong on those occasions? I have made a question to indicate that taking of human life is not always and everywhere morally wrong, and there are at least some justifiable killings like self-defense. Okay, let's proceed to the second one, which is allowing someone to die, mercy death or mercy killing, or euthanasia. Is euthanasia mercy or murder? We define euthanasia as the termination of a very sick person's life to end their pain and suffering. Forced exit, as they say, because they have no choice. Some people call euthanasia as mercy killing, but it is also against the law in some countries like UK. West's Encyclopedia of American Law also
Application of the jury in the issue of lying. During an interrogation, police cannot use physical force, so they resort to various psychological tactics. During an interrogation, police can lie and make false claims. For example, Law enforcement can lie to a defendant and say their compatriot confessed when the person had not confessed. Police can also claim they have DNA evidence, such as fingerprints, even if no such evidence exists. There are also limits on misrepresentation. While lying and trickery permitted to an extent, the tactics must be within reason and vary on a case-to-case basis. Police is not permitted to misrepresent a suspect's legal rights.
Good day. My name is Jeremy Cyril S. Ragos and I will explain to you the evaluation of criminal justice ethics. Its contents are introduction, evaluation in theory, evaluation in practice and example, and conclusion. Introduction. Criminal justice ethics is a study of ethics that is applied in the area of law enforcement. It is interconnected to integrity and public trust. Without these two variables, we cannot properly execute the ethics in criminal justice. Evaluation in theory. We evaluated the criminal justice ethics theory as a wonderful breakthrough through human behavior. It is a highly valuable ethics that is needed for the development of mankind. We give it a high praise because trust is the foundation of humans, and criminal justice ethics revolves around trust and learning how to trust people. Evaluation in practice and example. However, in practice, it is very low scored for us compared to its theory because of humans. Humans are opportunistic animals. They will do everything in order to gain control for every situation. For our example, in a court where two parties are fighting for murder, the defendant employed the best lawyer in town, while the plaintiff only have the lawyer given by the government because of lack of funds. Let's assume that all variables are constant except for the lawyers. We can definitely know that the defendant will win the case. Money controls everything. It is an instrument to break trust, to bring chaos, and even to bring war. And we can see that many juridical places are being corrupted by money. We humans forget that theory of criminal justice ethics for our own good. Conclusion. To conclude our evaluation, criminal justice ethics theory is so good for the benefit of mankind. However, criminal justice ethics that is done in practice is so bad because of lack of trust in the juridical system and in the police force. Thank you.
Hello again, I am Tony May Cardozo. So, let's start the discussion. Law enforcers should always act ethically. Unfortunately, it is not always the case. Police officers and attorneys often end up in morally ambiguous situations. In many cases, they don't do what the public deems the right thing. Here are some questions about criminal justice ethics. The first, discuss the ethical consequences of lying when working in criminal justice. Second, should the police be allowed to access everyone's data? Third, should law enforcement visibly wear gun in public? Fourth, when is the capital punishment justified? And the last is, what moral obligations should someone consider when granting prisoners the right to work? So let's first discuss the ethical consequences of lying. So let's discuss the ethical consequences of lying when working in criminal justice. Claiming, 1996, discusses consequences of police lying and identifies 3 deleterious consequences. The first, others are harmed, may occurs in sense that persons are led to do what they have not chosen to do. May also be deprived of possessions or placed at physical risk. Second, social trust is destroyed. Person lied to and who discovers lie suffer consequence of cynicism. May in return affect interactions with other because suspicion erodes trust. The liar is harmed. May occur through liar becoming more evasive for fear of being found out, developing suspicion of others, and perhaps developing reduced ability to resist other forms of corruptions. So, the scope for lying is very narrow. It should be used sparingly for serious investigations by officers who know the boundaries and what would be accepted in court. However, the ethics around lying leads some officers to discount it as a tactic. It is their duty to do what they can solve a crime. However, lying does not follow Kantian logic because the act itself is wrong. The duty is to solve crime, not to lie. Furthermore, Kant would argue that the officer is using the person as a means to an end to get confessions. Solving crime means you have to play at the criminal's moral level at times, and that as long as the evidence is admissible, anything goes. This perspective brings officer dangerously close to crossing the ethical line, venturing into novel case corruption. Officer must, in this case, be aware of the limits allowed by the courts and not be tempted to surpass these limits. So let's go to the next question. So, second is, should the police be allowed to access everyone's data? All the forces of technological age operate to narrow the area of privacy and facilitate intrusions into it. In modern terms, the capacity to maintain and support this enclave of private life marks the difference between a democratic and totalitarian society. In right of privacy under Philippine law, a survey of jurisprudence, the right to privacy means the right to be let alone and is the beginning of all freedoms. In Philippine law, the concept of privacy is enshrined in the Constitution and is regarded as the right to be free from unwarranted exploitation of one's person or from intrusion into one's private activities in such a way as to cause humiliation to a person's ordinary sensibilities. It has been described as the most comprehensive of rights and the right most valued by the civil man. So, the police is not allowed to access everyone's data because the data is privacy, is our privacy. So, let's go to the next, the fourth. So, this is the third question. Should law enforcement visibly wear guns in public? Yes, they are allowed to wear their guns in public, not to display. They are wearing their guns to prevent crimes, to protect, to intimidate law violators. And under Section 28 of Republic Act number 1059-1, also known as the Comprehensive Firearms and Ammunition Regulation Act, prohibits the unlawful acquisition or possession of ammunition and penalize the offense with a minimum prison term of 6 to 12 years. In order to possess a firearm in the Philippines, a person must be at minimum age of 21 and pass a background check to be issued a possession license. They must also take a firearms training and safety course. Filipino can carry pistol and handgun in public by acquiring permit to carry. So this is the fourth question. When is the capital punishment justified? Capital punishment is often justified with the argument that by executing convicted murderers, we will deter would-be murderers from killing people. Statistical evidence doesn't confirm that deterrence works, but it doesn't show that deterrence doesn't work either. Some of those executed may not have been capable of being deterred because of mental illness or defect. Some capital crimes are committed in such an emotional state that the perpetrator did not think about the possible consequence. No one knows whether the death penalty deters more than life imprisonment. To make an analogy, a child learns not to put their finger in the fire because the consequence is instant pain. The more the legal process distances the punishment from the crime, either in time or certainty, the less effective a deterrent the punishment will probably be. And guilty people deserve to be punished. Only guilty people deserve to be punished. And guilty people deserve to be punished in proportion to the severity of their crimes. Real justice requires people to suffer for their wrongdoing and to suffer in way appropriate for their crime. Each criminal should get what their crime deserve, and in the case of murderer, what their crime deserve is death. The measurement of punishment is given case must depend upon the atrocity of the crime, the conduct of the criminal, and the defenseless and unprotected state of the victim.
What moral obligation should someone consider when granting prisoners the right to work? As a human beings, all prisoners shall be treated with respect due to their inherent dignity and value. Just like every person in this world, prisoners have life and feelings. No matter what they have done, we should always learn how to value and respect them as a human.
That's our presentation about criminal justice ethics. So again, we are the student of accountancy. Thank you, God.